So we will have the last topic of institutional law of the European Union as the relationship between national law and EU law. The relationships between national law and EU law. As far as this relationship is concerned, we state that there are two different aspects of this relationship. One aspect is that there is this relationship of cooperation between EU law and national law, whereas in the second aspect, there is a relationship of potential conflict. What do we mean with the relationship of cooperation? We mean that these two legal systems, that is to say, EU law and national law, have to assist each other to achieve the objectives of the founding treaties. Therefore, these two legal systems, national law and EU law, had to assist each other to achieve the objectives of the founding treaties. These two legal systems share the same aim, right? They both aim to achieve the objectives of European integration. And the member states are under an obligation not to jeopardize the objectives of European integration. Jeopardize? Tehlikeye atmak. Therefore, as far as the relationship of cooperation is concerned, we say that the national law and European Union law help each other, assist each other. Can you give me examples showing me that there is a relationship of cooperation? Yes, Khan?
Can we say guidelines prepared by to elaborate the principles of law?
No, with then no guideline. You could say the law itself has to be followed by the national legal systems. No, I want more precise examples showing us that there is. Yes, Dennis?
May I say preliminary ruling procedure?
Preliminary rulings procedure is a good example from the judicial sphere. Who assists the other there?
Court of Justice assists the national court to interpret the EU law.
Exactly. The Court of Justice assists the national court for the uniform application and interpretation of EU law. What else? Yes, Öykü?
Maybe the transposition of directives.
The transposition of directives. Directives are sources of European Union law. Is that true? Yes. But they are not directly applicable. Therefore, for their implementation, we need transformation or transposition of directives into the national laws of the member states. What else? We have given two examples today without knowing that they were examples for the relationship of cooperation. Yes?
Member states and European Union, when they do an international...
No. Shared competence is not an example. Yes, Dennis?
We said that in the actions of damages, Court of Justice looks at the national laws.
Exactly. In the actions for damages, the founding treaties provide that the Court of Justice makes the damage, the good, any damage given by its institutions or by its servants by looking at the or in accordance with the general principles common to the laws of the member states. So this was one example. Another example was
Armed agreements.
no. We said that when there is no exclusive jurisdiction for the Court of Justice, but when there is a dispute arising from European Union law, who will see the case? The national court. In such cases, the national courts shall act as EU courts, meaning they will apply European Union law as the EU courts, as if they were EU courts. And another example, we mentioned last week that there are no law enforcement agencies of the European Union, the law enforcement agencies. Therefore, when the law needs to be enforced, who will enforce it? The national law enforcement agencies. Therefore, there is a relationship of cooperation because these two legal systems want to achieve the same thing, the aims, the objectives of the European integration, and therefore they help each other, they may assist each other both legally or in the legislative sphere, executive sphere, and the judicial sphere. The second aspect of this relationship is the relationship of potential conflict. Why is it so? Why there is this possibility of potential, or potentially there might be a conflict between these two legal systems? Yes, Öykü?
Maybe the national law cares about the interest of the nation, but the EU law cares about the interest of all individuals and EU members. So sometimes the nation's interest might not be the same with the EU's interest, then there might be a conflict.
But why is it important then? Turkish law may be in conflict with German law. Would this be something very important? We would just say, well, they are in conflict.
In order to use EU law prevails principle.
No. Why there is such principle even? Yes, Atakan?
To perform uniformity.
No. I'm asking about the reason. Yes, Enes?
We have a legal system here, so this is a new legal system, and we have to keep it certain, and we have to keep it in conformity, and we have to provide uniformity in the EU legal system.
No.
Okay.
Okay, you tell me, when German law is in conflict with Turkish law, would this be something very important for us? No. We would just state that there is a conflict in this area with German law, for example. Why is it important when German law is in conflict with European Union law, for example? Why would they develop certain principles, as I will be explaining, to solve this conflict? Very easy answer. Yes, Deniz?
Because they have to know which law system should be applied.
Why? True.
Because normally, if it is a case concerning that EU law should be applied, but maybe it's not that certain if it's a case concerning EU law or an ordinary law.
There is this potential of conflict because they apply in the same territory. They apply in the same territory. Where does national law apply? In the territory of the member states. Where does the European Union law apply? In the territory of the member states. Therefore, here we have two legal systems, national law and EU law, which apply in the same territory, meaning the territory of the member states. These two legal systems, therefore, apply in the same area simultaneously. And for the potential of conflict, the Court of Justice have developed certain principles to solve these conflicts. The Court of Justice have developed certain principles, and we call them conflict principles. These principles also provide for the characteristics of European Union law. I will be speaking about 6 main principles. You will find references to these principles in your chapters in the book. First, generality of EU law, or the EU law is general. What would mean this, that generality of EU law? Yes, Deniz?
EU law must be applied in general, regardless of where the state appears or where the state locates. I mean, in the European continent, it should be applied everywhere.
But only for the EU member states. The EU law is applied in all the member states and for all the individuals. Therefore, the EU law is binding both on the member states and on the citizens of those member states. Second, uniformity of EU law. This principle complements the first one. It means that the EU law is applied in all member states, or it is binding on all member states and on all citizens, and it must be applied at the same time, in the same manner, with the same meaning, in all the member states of the European Union. It has to be applied at the same time, in the same manner, and with the same meaning. And as we've stated before, for its uniform application and interpretation, the Court of Justice has the monopoly. The third principle is the principle of autonomy of EU law. Autonomy, özellik. What would that mean? That the EU law is autonomous. It is an autonomous legal system. What do we mean here? Yes?
We mean it's independent from the national and international law.
We mean that this new legal system has sui generis characteristics. It is a sui generis legal system. In Turkish? Nevi şahsına münhasır. It is a sui generis legal system, meaning it is independent from national law and international law. Therefore, the EU law, because it is autonomous, cannot be amended or repealed by a unilateral act of the member states. It cannot be amended or repealed by a unilateral act of the member states, or cannot be interpreted by national courts. It can only be amended and repealed and interpreted by the institutions of the European Union.
What does repeal mean?
Repeal? Abolish. Yürürlükten kalkma.
What does unilateral mean?
Unilateral? Unilateral, bilateral, multilateral. Unilateral, tek taraflı. Bilateral, iki taraflı. Multilateral, çok taraflı. Then, fourth, is it fourth? Yes. Direct applicability of EU law. We have mentioned this. This is a characteristic of regulations because they aim for uniformity in EU law. I'm not going to explain it again. Okay? The next principle is the principle of supremacy or primacy of EU law. What would that mean? This principle of supremacy or primacy of EU law.
EU law prevails.
Does the EU law always prevail?
Yes.
Sure?
Yes.
The EU law prevails only if there is a conflict between national law and directly effective EU provision. The EU, according to the established jurisprudence of the Court of Justice, where there is a conflict between national law and directly effective provisions of EU law shall prevail. The principle of supremacy was firstly provided in 1964 Costa Enel decision of the Court of Justice, and then further provided in 1974 in Cimental case. We will be hearing a presentation on the Costa Enel. It should also include certain points on the Cimental case. According to the Costa Enel case, this is a legal system which is accepted on the basis of reciprocity. Reciprocity? Karşılıklılık. Therefore, as we have mentioned, there is no possibility to amend or to repeal a principle of EU law by a unilateral act of the member states. When there is a conflict between them, between a national law or a national provision and directly effective provision of EU law, the EU law shall prevail. Further, in Cimental case, the Court of Justice provided that directly effective provisions of EU law prevails whether they are prevails in any case, being independent from the fact that national provision was adopted prior or subsequent to the EU provision. Prior, before, subsequent, after. Therefore, it is irrelevant. Okay? The national provision might have been adopted before EU law, EU provision, or after EU law. Okay? Therefore, the principle of supremacy or primacy, meaning the same thing in this class, enables a directly effective provision of EU law to render a conflicting national provision automatically inapplicable. A directly effective provision of EU law makes, therefore, a conflicting national provision inapplicable from the date of its entry into force. It also precludes the national parliaments or the national authorities to adopt a conflicting national provision, and it also puts the national judge not to apply the conflicting or to set aside the conflicting national legislation. The judges, therefore, the national judges, are also under an obligation not to apply conflicting national legislation. The supremacy of European Union law is not provided in the founding treaties as a provision. This is a principle, a very important principle, of course, developed by the Court of Justice of the European Union since 1960s, and it was not very easy to adopt such a principle in European Union law. But today, or following the Lisbon amendments, principle of primacy or supremacy is now provided under a declaration annexed to the founding treaties, and it provides, in summary, that the principle shall be continued to apply as decided in the case law of the Court of Justice. Then lastly, we have the principle of direct effect. Who can tell me the principle of direct effect? Yes, Deniz.
Individuals, by looking at the provisions of these articles or regulations or directives, may claim their rights before the national courts, but they have to look at the provisions. Our main focus is here provisions.
Exactly. We speak about direct effect of provisions, be it in the founding treaties or in the accession treaties, international agreements, regulations, directives, decisions. We always apply the same criteria to find out whether the provision is directly effective or not. This is the criteria provided by the Court of Justice itself in its case law. According to the court, the provision must be clear, precise, and unconditional. The court started to develop the principle of direct effect since the early days of the European integration in one of the very important decisions of the Court of Justice. In 1963, in Van Genen-Low's case, the Court of Justice said that the direct effect, the principle of direct effect, gives the individuals the rights to be claimed before the national courts. Therefore, 1963, Van Genen-Low's case, you will be reading about this case as regards the free movement of goods as well under Article 12 of the EEC Treaty at that time. And this is a landmark decision also about the principle of direct effect. Therefore, for a provision to be directly effective, it must be clear, precise, and unconditional, meaning that a clear and precise provision provides for an obligation on the part of the member states, the scope of which is perfectly defined. A clear and precise provision provides for an obligation on the part of the member states, the scope of which is perfectly defined. This obligation may be a positive or a negative obligation. It may provide a negative obligation, meaning a prohibition. An obligation on the part of the member state may be a prohibition, which will be drafted as refraining or obliging the member states to refrain from doing something. Refrain? Kaçınmak. To refrain from doing something. Or this obligation may be a positive obligation, obliging a member state to act in a certain way. And this provision must be unconditional, meaning that it must be implemented independent from the discretion of member states or discretion of any institution or a judgment of any institution. All in all, when we have a directly effective provision of EU law, this shall have two important consequences. First, you can tell them now. Two important consequences of directly effective provisions of EU law.
Can be claimed in the national court before the national court.
Exactly. Directly effective provisions of EU law give the rights to individuals to be claimed before the national courts. According to the Vangen and Low's case, directly effective provisions of EU law give rights to individuals which will become part of their legal heritage. The directly effective provisions of EU law provide for rights for individuals which shall become part of their legal heritage. And this is a uniqueness of European Union law, different than international law, which provides mostly obligations and rights for the contracting parties and not specifically for the individual. But individual is at the heart of the EU's legal system. And secondly, the second consequence is, of course you would know that as well, when there is a directly effective provision of EU law. Yes, Umut? Meaning, when there is, yes, when there is a conflict between national law and directly effective provision of EU law shall prevail. Okay, so by now we have finished the institutional law of the European Union. I think you have a very good basis for European Union law now. For in the world, the EU law courses always start with institutional law, or sometimes the whole course is dedicated to the institutional law of the European Union. This was the case at Bilkent since this year, as you know, or until this year. Now we have changed the syllabus of this course, but this part, this big part or a bigger part, is always about institutional law of the European Union law. If you have a very good basis on institutional law, then you are at the safe side. You have no problem at all, mostly on the substantive law. You can have no big mistakes about substantive law, because we build always substantive law on the institutional law of the European Union. All right? Thank you very much. See you next week for substantive law.